Good afternoon and welcome. We're really glad that you're joining us today for what we know will be a very helpful and informative webinar. My name is Marta Young. I'm an attorney and I work on our learning team here at BARBRI. And I want to welcome you to this webinar entitled How to Succeed in Law School, something that's probably on a lot of your minds. Today, you're going to hear from a true expert on this topic, someone who is not only the Dean of Emory University School of Law, but also a professor. His areas of expertise are civil procedure, business associations, and complex litigation. He has authored 17 books and is the only person to serve as a contributing author on two multi-volume treatises on federal jurisdiction and practice. He's also an award-winning teacher and someone who has helped about 500,000 people pass the bar exam. Now, I know sitting here at the beginning of law school, the bar exam probably feels a long way off, but in order to get to the bar exam, you're going to have to pass some final exams along the way. So with that being our mission for today, it is my distinct pleasure and honor to introduce you to Dean and Professor Rich Freer, who's going to help you be more successful in law school. Quick note, feel free to drop any questions in the Q&A box. We're certainly going to reserve some time at the end to answer as many questions as we can. But with that, Dean Freer, I turn it over to you.
Marta, thank you for that nice introduction, and thank all of you for being here. And I start with words of congratulations. You should never lose sight of this fact. Think of how you dreamed about going to law school and worked really, really hard here. And now you are here. You deserve to be here. I know first year can get a little stressful, but do not doubt yourself. You're here, you belong here, and let's maximize the experience. You know, being a professor is the best job in the world because you get to know these students, you get to work with them, and you see their careers develop. And after they graduate, you stay in touch with them. And so many of them have been friends, and I have 42 years worth of former students out there. And one of them dropped by to see me not long ago, and we hadn't seen each other in years. And we chatted and we got caught up. And then he said something very serious. He said, "Professor, I want to tell you something very important." And he said, "If I had 1 hour left to live, I would spend that hour in your classroom." Well, I was choked up. I was getting overwhelmed. And then he said, "Because as I remember it, you can make 1 hour seem like forever." So hopefully today's session will not seem like forever. Let's talk about this first year of law school. It is exciting. It is exciting. Can be a little stressful. Let's de-stress it to a degree. And we start that by understanding why and how law school is different from college. It is. It's just different. Why is law school different? Well, that's pretty easy to answer because here we are being educated and trained to practice a profession. And that was not true for most of us in college. Most of us were liberal arts majors, and we were not going to make a living by using what we studied. But here in law school, we are being trained for our professional life. And so it's very important to understand that law is a problem-solving profession. No matter what area of law you go into, no matter who your clients are, they're going to hire you to do one thing, and that is to solve problems. And that tells us a lot about why law school is the way it is. It's a problem-solving profession, and that's what makes it a noble profession. You're going to dedicate your professional life to solving other people's problems. Now, that affects us here in law school in this way. When you think about it, in college, for most of us, liberal arts majors anyway, learning the material in college, that was an end in itself. Really, our goal with exams and papers was to demonstrate to the professor that we had learned the material, we understood it. Law school is different. Here, our job is not simply to demonstrate that we know the relevant law. We do need to know the relevant law, and we will. But our job is to demonstrate that we can use that law, use the material we learn to solve problems. And those problems are posed by a fact pattern on the exam. So that's what lawyers do. But knowing the law is not the end in itself. It is our tool for showing the professor how we solve problems with the law. Now, that's why law school is different. How is law school different from college? Well, one way are the materials we study. In college, usually we would read texts, and the text would often tell us what we needed to know. But law school, it's different. Here, we don't really have texts. We have case books, not textbooks. Now, what's the difference? Case books are full of the raw materials that lawyers use. And the main raw material is case law, opinions by judges deciding real world disputes. And we also have statutes and federal rules of civil procedure and restatements, a whole bunch of raw materials. And so our case books are aimed at the raw materials, not exactly telling us what the law is, but those are the tools we use because those are the tools that lawyers must use to figure out what the law is. But let's face it, the biggest difference between law school and college is the way we grade. In most law school classes, 100% of the grade is going to be on the final exam, particularly maybe in the first year. Now, that certainly was never true in college. So, in most classes, if your grade, the entire grade is riding on the final exam, that is a cause for a little nervousness. It's a Pepto Bismol moment, but you're going to be nervous about it, but so is everyone else. It's new to everyone. And the way to avoid anxieties when exams roll around is to work smart in the meantime. You can do so much to lessen that anxiety when the exams roll around. So let's think about the exam for a minute. On the procedural aspects of the exam, your professor is going to tell you. Probably the rules are in the syllabus for the course. But questions like, what is the length of the exam? What's the format? Is it essay? If so, are there word limits? Is it multiple choice? Short answer? Is it open book? And even if the prof says open book, maybe you need a definition of what that means. Can you just bring in the case book, or can you bring in anything, or can you use the internet? Those are all fair questions. And just ask your professor if she hasn't already told you, but probably all of that's in the syllabus. Now, on the substance of the exam, as you study, keep in mind that our job on the exam is not simply to show the professor that we learned the material. Our goal is to use that material to solve a problem. Now, because of that, on a law school exam, you're probably not going to get a question like, what are the elements of the tort of battery? Or what is in rem jurisdiction? You're not going to get those questions. Why? Well, because in the history of the world, no client has ever asked a lawyer that. No client ever ran into a lawyer's office and said, tell me, gotta know, what is in rem jurisdiction? No, that's not the way it works. A client is going to tell you a story. A client is going to give you a fact pattern. And that's why law school exams are not questions about what the law is, they are fact patterns. And you, as a problem solver, determine which facts are relevant. You apply the facts to the law and you reason through to a conclusion. You solve the problem presented by the fact pattern. So the question here is not whether you know the elements of the tort of battery, but do you see them on the fact pattern? And then you go ahead and explain how the problem should be solved. So on an essay question, I think it's not enough simply to show that you know the law. You will know the law and you've got to know the law, but the points you earn on that exam will come from applying the facts in the fact pattern to the law. You come in there with the law in your head. Professor gives you the facts. You apply the facts to the law, and then you come through to a reasonable conclusion. So you want to find the facts that relate to the law. And that's where the points are on the exam. Now, to start off, of course, we need to know the material, and you're learning the material in your courses. But we have a handout, and I think you've been given this handout. It's just 2 pages, front and back of one page, how to succeed in law school. And on the first page, we have 4 suggestions, just suggestions about learning the material. Now, these are really simple and they're common sense. And again, these are not rules. These are just my suggestions, having taught law for a long time. But I urge you, find what works for you. But still, I think you'll find these helpful. Number one, read the assignments. Try to get the reading done. I know the reading is unclear. You read it and say, what is this about? But everyone's in the same boat on that. But try to get it done. That said, there will be times life intervenes. There will be times when you don't get through it, but give it the try. Try to get the reading done. Number two, I think you always go to class. Always go to class. I remember thinking, oh gosh, I'm unprepared today. Should I go to class? And I learned, yes, you go to class even if you're unprepared. I mean, the worst that can happen is you get called on and you simply say, I'm sorry, professor, I'm not prepared in class for today. Now, in class, why are you there? Focus. Learn what the cases mean. You will have read these cases and statutes and rules, and you want to find out what the prof thinks the important points are. And let me give you a hint. Professors will almost always give a clue of what exam questions might look like. So my advice to you is, in class, write down every fact pattern that your professor gives you, because each one of those could be an exam question. So, for example, you read a case, and in the case, the facts were A, B, and C. And when the facts are A, B, C, this is the result. Now, in class, your professor might change the facts. All of a sudden, the facts are A, B, and X. Now, does the case come out the same way? Write those hypos down and take advantage of what she tells you, what the professor tells you about how to resolve those. So in class is where you find out what the professor thinks is important and maybe some hint of what an exam question might look like. Third, you must review. Folks, please, please, please understand this. You cannot cram in law school. There's too much material. We got away with it in college, let's admit, but there's too much here. And I think there are 2 kinds of review to ponder. First is one that very few people do, but give it a try. And it's daily review. Now, it's not a big deal. It's not a big deal. What I'm saying is this. Each day after class, that evening, take 5 minutes. Just take 5 minutes per class. Go over your notes from the class and write yourself a note about what the professor considered important in that class. Because this happens all the time. You go in there thinking the important thing here was X. And it turns out, according to the professor, the important thing was not X, it was something else. Write that down that night while it's still fresh in your mind. I think it's a big mistake students make is to write down their notes that day and then they don't look at them for a while. Don't let that stuff get stale. And you might do this daily review along those lines. The second kind of review everyone does, and it's periodic review, often called outlining. I prefer the word distilling. And here's my suggestion. That's all it is, just a suggestion. At the end of each big topic in each class, at the end of, let's say, each Roman numeral in the syllabus, find some time. I always did it on the weekends. Find some time that weekend to distill that, all that material in that Roman numeral in the syllabus, synthesize it. So you'll have your class notes here, your case book here, and you want to create a new document. You're not rewriting your notes. You're distilling it, shortening it, summarizing it, making a checklist. Get the law down in some kind of abbreviated summary form. And what I'm suggesting is that what you spent maybe 2 weeks on in class, you might be able to reduce in an outline to, I don't know, 2 or 3 pages. But that's going to depend on how you do it. Everybody does it differently. There's no right or wrong way. And a lot of it will depend on your comfort level with the material. But the point is, you're creating a new document. And the deal I had with myself was if I did not understand it completely, I was not going to put it in my outline. You do the heavy lifting there over the weekend. And the brilliance is that when exams roll around, you don't need to go back and look at pages of notes. You don't need to go back with a lot of time in the casebook. You've done the heavy lifting. All you need to do is review a page or two or three about each Roman numeral in the syllabus. You've made the connections. So the way to lessen anxiety at the end of the semester is to do the work now. Do it in September, October, November. You're going to pay dividends here. I promise. It's going to build so much confidence to go into exams knowing that you've done that distillation. Now, as you do this distillation, as you outline, if something is unclear, there are certainly study supplements out there. West Academic has many of them. And don't forget office hours. Again, the professor's job is the best job on the planet. The only problem is it's really lonely because we wait and wait and wait during office hours for students to show up. But usually it's like waiting for the Comcast guy because folks don't show up. Please do yourself a favor. Any questions you have, go to the professor, office hours. The fourth thing I suggest is work on practice questions. Each prof might provide questions. There may be old exams on file. Some are commercially available. And working through those hypos builds confidence. If you have sat down and actually written out answers to a couple of essay questions before exams, wow, that does you a lot of good. Just builds your confidence. The way I did it, and I just got lucky with this because a friend of mine suggested it, is that I did it with a friend. And we would get together, and let's say we had a 45-minute essay question, and he and I would sit down in a room and take that exam question under exam conditions. So we do not talk to each other 45 minutes. We work through it. We write out our whole answer, and then we read each other's answers. Oh, man, that was great because invariably you'll see things that your friend did not, and your friend will have seen things that you did not. And you both benefit from that. It is a wonderful exercise. Now, that means there's a lot to do in law school, sure. But folks, it's law school. It is not law prison. You can and you should have a life. But law school does take discipline, and that's a good thing. This is manageable. You still have time for the baseball playoffs, for college football, whatever it is that is your hobby. But it does take discipline and it does take organization. Now, in our handout, we've had 4 suggestions about learning the material. What does this distilling or outlining, synthesizing look like? At the bottom of that page, I have an example. And it's an example of the distillation, what it might look like. It just is a summary of a particular subject. And again, your outline is not a rehash of your notes. It is a summary, not a repetition of all that stuff, but you're distilling it to checklist what you need on that exam. And this is an example from civil procedure. And I know on this big Zoom meeting, I can't really ask for a show of hands, but I'll just take it as a given without voting that civil procedure is everyone's favorite course. We all know that. And this is from federal subject matter jurisdiction. Now, you know what this is. Federal courts can only hear certain kinds of cases. One of those cases is diversity of citizenship. Now, how might we distill diversity? This is simply one suggestion, and it's pretty sparse. This is not the only way to do it. Yours will probably have a little more detail here and there, but the point is to do it for yourself. You are creating a document for yourself. The joy of an outline is not reading it. The joy of an outline is writing it. So when we look at diversity of citizenship jurisdiction in this handout, you'll notice there are two basic requirements. Number one, the complete diversity rule. That means no plaintiff can be a citizen of the same state as any defendant. And in addition to that, the amount in controversy must exceed $75,000. So we go in, and those two checkpoints are there. We know that. Now, let's drill down on both of those requirements. How do we determine citizenship? How do we do that? Well, as this very sparse checklist shows, for a human being, your U.S. state of citizenship is the U.S. state in which you are domiciled. Domiciled. Now, as you know, everyone has a domicile, and you only have one domicile, and whatever the domicile is, that is your state of U.S. citizenship if you're a U.S. citizen. But how do you change your domicile? Well, it tells us right here. It takes two things to change your domicile. Number one, physically, you must be present in the new state. And secondly, you must have the intent, the subjective intent to make that your permanent home or your home for the foreseeable future. Now, when we are outlining like this, and again, this is pretty sparse, but when we're doing this, I want you to psych out the exam. If we have an essay question in this area, which one of those two requirements for changing domicile is likely to be the more difficult? Well, not physical presence. I mean, physical presence is pretty obvious, isn't it? I mean, either the person is in that new state or is not in that new state, right? Bigger issue likely will be intent. Did that person have the intent to make that new state her permanent home? Now, folks, you're going to know the law. The fun about an exam is you've got to find the facts. Find facts that are relevant to this person's intent to change a domicile. For example, suppose the professor on the exam tells you that the person bought a house in the new state, took a job in the new state, registered to vote in the new state, joined a civic club in the new state, joined a faith community in the new state, qualified for in-state tuition in the new state. Folks, that is 6 facts. Those are 6 facts right there that would be relevant toward intent. On the exam, everybody in the room is going to know the rule, but knowing the rule is not the goal, not the only goal. You got to know the rule. You must apply facts to it. And if there are 6 facts in the fact pattern, your grade will depend on how many of those you saw and applied. Somebody who gets all 6 is going to get more points than somebody who got 2. But let me caution you about something here. Nobody over the course of an exam gets all the points. Nobody. You know, don't let perfection be a problem here. You and I are just people. We don't do perfection. So nobody gets them all. Make it kind of fun. Go in and read aggressively. And you're already going in thinking, wow, intent might be a problem. So your mind starts working on that. Wow, okay, now I'm looking for facts that might show a change of intent, something like that. The rest of this distillation is just other rules in the area. Corporation is a citizen of the state of incorporation and the state where it has its principal place of business. And the PPB, principal place of business, usually is where the nerve center is, etc. An unincorporated or non-incorporated business like a partnership or LLC, we don't look at where it's formed. You look at the citizenship of all the members. I'm simply suggesting that you want to put those rules down in a checklist fashion. Same thing on amount in controversy. It's got to exceed 75,000. And remember, we can aggregate the claims by one plaintiff versus one defendant. We can add them all up. You know the rules, but come up with a way in which to distill them into a checklist. And again, it's likely to be longer than this. This is simply an example. What I'm saying is that what we've spent 2 or 3 weeks on, subject matter jurisdiction, you might distill to, I don't know, 2 or 3 pages. And the beauty of that is you know it because you wrote it. You wrote it. You made that distillation. You made that outline. And you review from that. So 2 pages on this subject, 3 pages here, so there, and so forth. And so you learned the material and got it outlined throughout the semester. You don't have to cram. Now, if you flip that paper over, we're going to go over to the next side, and we have 6 suggestions about exams. Here I'm focusing on essay exams. And this is just suggestions. That's all. This is not sacrosanct in any way, but they're suggestions. Number one, budget your time. Please budget your time. Law school essay exams are usually pretty time intensive. Your prof is probably going to give you time suggestions, and that's a very important proxy for how many points are there. A 30-minute question will have roughly half the raw points of a 60-minute question. So you don't want to spend 45 minutes on a 30-minute question because there are only 30 minutes worth of points there. It takes discipline, it takes practice, and that's why you want to do practice exams. As you get toward that 30 minutes on that 30-minute essay, try to wrap it up and get on to the next one. You don't want to rob yourself of time on that next one. Number two, on an essay exam with multiple essays, I would address one essay question at a time. If there are, let's say, 3 essay questions with different fact patterns, it's an enormous waste of time, in my opinion, to read them all at the beginning. Don't do that. You don't have time. Take question number 1 with all of its subparts and do it, finish it, complete it, write it out, and then go to question number 2. I think you'll be better off if you do it that way. Number 3, I suggest this, but again, try this and see how it works. I suggest on essay questions that you read each question twice. Now, some people do this, some people don't. That's fine. Try this in practice and see. The first time through, you read it rather quickly, kind of like you might read a magazine article. And what you're looking for here is the gist. What is this about? Is this an intentional tort or is it negligence? Is this formation of a contract or is it breach? What is this? And in that first read, focus on the call of the question. The call of the question is what the prof wants you to do. What is it you're being asked to do? Now, second time you read it, you know the call of the question, what your task is, and your mind's already working on this because now this is about contract formation, blah, blah, blah. Your mind's working on it. And as you read through it now, you read it more slowly, more carefully. You read it, what I say, aggressively. And a good habit to get in is this. For every fact you see, ask yourself, why is it there? Why is it there? Is this something about offer or acceptance or what is it? There may be some facts that are in there for no reason. That's fine. But look at each fact and don't let them slip past you. Don't let them slip past you. Now, number 4, this is, I think, very important. For every single issue in an essay exam, you're going to state the issue. The issue is whether service of process is proper or whatever it is. After you've stated the issue, friends, I think you must do 3 things. And I would always do them in this order. Number 1, state the relevant rule. Lay out the rule. Number 2, apply the facts. Remember, we were reading it. Why is this fact here? Why is that fact here? Oh, this one goes to this issue and so forth. Apply the facts to that rule. Apply the facts to that rule. And then number 3, come to a conclusion. That's IRAC. That is IRAC. And I would keep this relentlessly mechanical. Every single issue, state the issue. Now, state the rule, apply the facts. That's where the money's going to be. Apply the facts to the rule, then come to the conclusion. And let me suggest three magic words. These are magic words in an essay: under, here, Here, and therefore. Why? If you are relentless about using those words, you will not miss any step. Under is your chance to state the rule. Under the federal rules, a process server must be a non-party who's at least age 18. So under, then you state the rule. Here is your key to apply the facts in this case. Here, the process server was 17 years old. Therefore, keys up your conclusion. Therefore, service of process was improper. Relentlessly mechanical. Rule, facts, conclusion. Over and over and over. So let's take that example. In Civ Pro, process must be served by a non-party who's at least 18 years old. So here's an easy question. We have a non-party served process, but she's 17 years old. Everyone in the class knows that that's no good, but not everyone will get credit for the answer. Why? Because some people will forget those three things: rule, facts, apply the facts, and conclusion. Some people will say, service is no good because the process server was too young. That's 100% right, and it's absolutely zero credit. None. Why? Because you haven't told us why. Relentlessly mechanical. Under the federal rules, the process server must be a non-party at least age 18. Here, the process server was 17. Therefore, service of process is no good. IRAC stands for issue, then rule, then A is apply the facts to it. That's also known as analysis. And then C, of course, is the conclusion. Be relentlessly mechanical. Number 5, on an essay question, expect some ambiguity. On every exam, there'll be some very clear issues like that service of process one we just did, but some are going to be hard. Personal jurisdiction, or is there a duty, or proximate cause? You like ambiguity on an exam because it allows you to show off. Because when you have ambiguity, you got to analogize. You know, the facts on an exam are never exactly like the facts of the cases you read. So again, example we mentioned before. In the case we read, the facts were A, B, and C, and it came out X. Well, now all of a sudden, on the exam, it's A, B, and I don't know, L. And the question is, should it come out X? Well, the answer is less important than arguing. You've got to be able to reason. Well, this is a lot like that case. Two of the factors are the same. On the other hand, here, one factor is different. Maybe that should be a different conclusion because, maybe it should be the same conclusion because. Ambiguity, don't let it scare you. This is your friend. That's why going to class and writing down all the fact patterns from the prof is critical, because profs change facts in class all the time. And that's something like what you're going to see on an exam, most likely. So embrace ambiguity. In personal jurisdiction Civ Pro, stream of commerce, there are two competing theories. You apply the one, you apply the other, you reason through, come to a conclusion. Usually, your conclusion is less important than your arguing both sides. Number 6, I propose that on an essay question, and again, try this in practice, allocate 1/3 of the time to outlining your answer. And I mean that like on scratch paper. Have a pencil and scratch paper. One thing students do sometimes and gets them in trouble is they start writing the answer too early. Now, this takes discipline, but do the heavy lifting in that first third. So a 45-minute question, I think 15 minutes or so. You're sketching it out on the scratch pad before you even write the answer. This is where you tie up the facts. This is where you're saying, okay, this is an issue about, whoa, this is an issue about Formation of the contract. Okay, here are the facts. This telegram said that, this email said this phone call says this. Put them all together so you know where you're going. And then by the time you write it out after about 15 minutes, and this is not by the clock, it's by feel, you know exactly where you're going. And practice helps there. Practice helps. Will you at some point see something you didn't see and say, oh my goodness, there's something? That's fine. Just deal with it when you see it. That's fine. That's fine. Just put it in. Relax. My message is relax. You are going to know the law. You're going to know the law. You're working hard on that now. The exam, essay exam, certainly boiled down to a scavenger hunt. Make it fun. You're looking for facts that are relevant to this issue or that issue. Let me show you what I mean. Let's wrap this up with a hypo. And this hypo is from personal jurisdiction in our favorite course, civil procedure. And this is going to be a constitutional analysis of whether there's personal jurisdiction under the famous case of international shoe. You might have a statutory issue there about a long arm statute, but all we're going to do right now is do the shoe. What is the international shoe analysis? Now, where it says here in our handout, a hypo, notice what I have here. This is, in my opinion, a pretty good outline of what international shoe requires. It's pretty doggone short, isn't it? And your outline can be longer. Absolutely no problem with that. But one of the things we're trying to figure out here is personal jurisdiction. What is personal jurisdiction? Personal jurisdiction is the court's power over the defendant. To enter a valid judgment, the court must have power over the defendant. And this is going to be in personam jurisdiction, which means power over the defendant's person, over the defendant herself. How do we get that? Well, constitutionally, there are these steps. First, you always must start with contact. There must be a relevant contact between the defendant and the forum state. Forum state is the state in which plaintiff sues. We're going to call it state X. So we're looking for a relevant contact between defendant and state X. Now, what are the rules for that? There are two. One, as we see in this little document, is purposeful availment. Purposeful availment by the defendant of state X. The contact between D and state X cannot be an accident. It cannot be the result of something somebody else did. The defendant must reach out to that forum, avail herself in some way of that forum, maybe to make money there, maybe to use the roads there, whatever it is. But you've got to find facts showing purposeful availment. And then there's a second thing the courts mention. Your prof might not think this is a big deal. I'll always go with what your prof says. But the Supreme Court occasionally refers to foreseeability. Is it foreseeable the defendant could get sued in state X? So those two things go into whether we have a contact. And if there is no relevant contact, there cannot be jurisdiction. So we're going to read a fact pattern, and we already know what we're looking for. We're going to be looking for facts, because that's where the money is, that show defendant's purposeful availment, and facts that may show that it's foreseeable defendant could get sued in state X. Now, let's say we have a contact. How does international shoe go then? We have to assess relatedness. And you'll remember from the Ford Motor Company case that if the claim, that is the claim by the plaintiff, arises out of or relates to the defendant's contact, that is a matter of specific jurisdiction. Specific jurisdiction is where the defendant's being sued in state X for something she essentially did in state X. But if it does not, if the plaintiff's claim against the defendant does not arise from anything the defendant did in state X, then the only way to get into court would be general jurisdiction. General jurisdiction is only where the defendant's at home, and you'll see the traditional bases there as well, and your prof will talk about that. You and I are going to focus on specific jurisdictions, so there will be relatedness here. The claim does arise out of or relate to what the defendant did in state X. When that is true, when you have specific jurisdiction, then there is a third step, and here it is. You must assess whether jurisdiction is fair or reasonable under the facts. These factors about fairness, there are five of them, and they're listed in a whole bunch of cases by the Supreme Court. There is no magic here. You simply have to go through each one and weigh them and determine whether specific jurisdiction would be fair on the facts of this case, fair or reasonable. Remember, the fairness factors are only relevant in specific jurisdiction, not general, but we're going to deal with specific. Now, you go into this essay question. Here's the fact pattern. You know what you're looking for. You are looking for purposeful availment, foreseeability. Relatedness is going to be a gimme. But then you're looking for these fairness factors. Is there going to be a burden on defendant to have to litigate in state X? Are there facts relevant to that? What is state X's interest? State X is the forum state. Does it have an interest here? These are relevant under Supreme Court precedent. Plaintiff's interest. Does the plaintiff have a legitimate interest in suing in this place? If so, what is it? Why? What are the facts? We're all going to know the law. The fun here is we got to find the facts. Efficiency is the fourth one. Where does this litigation make sense? Where are the witnesses? Where should the trial be? And then a fifth fairness factor is shared social policies. I've never figured out what that means. So if you find out, maybe you can drop me a line. Your prof might make something of that. There are a couple of cases that have mentioned it. Now, let's go on a scavenger hunt. We all know the law. We all know the law. Scavenger hunt. Let's make it fun. D, who raises horses in Kentucky. So D is always the defendant. Raises horses in Kentucky, sent a horse to participate in a prestigious horse show. And I'm just curious, why is prestigious in there? Maybe it means nothing, but okay, prestigious horse show at a new municipal arena. Why is that there in state X? D did not attend the show because she was to attend another show in Europe at the same time. Why is that there? Why is that there? Of the checklist up above, what is that relevant to? This is how we take exams. We got the checklist from the law. Now we're using the facts. But she ensured that her horse farm would be advertised at the show. She also requested police protection for the horse at the show. What does that show us? What does that show us? At the show, something startled the horse. The horse went berserk and ran into the crowd. The horse trampled plaintiff, who was one of the police officers serving as part of the security detail. So the plaintiff who's injured was a police officer, part of the security detail. Plaintiff suffered serious permanent physical injuries requiring lifelong treatment. Why is that there? Of the checklist, what is that relevant to? P sues D in state X, seeks damages. Now check this out. In excess of the liability insurance coverage that she arranged for when she accepted the offer to show the horse in state X. What does that tell us? What does that tell us? D may have foreseen litigation? Maybe relevant? Would the court's exercise of in personam jurisdiction over D be constitutional? Let's do the shoe. First, what facts show us that the defendant did or did not avail herself of state X? Okay, what facts are in there that show us that D did reach out to state X? Well, I think there's several. One, she sent the horse directly to the state. This is not stream of commerce where she sent the horse to Wyoming and it galloped into state X. She sent it directly there, reaching out to state X directly. What else? Hmm. She advertised. Oh, yeah. Her horse farm was advertised at the show. What is that? That's availment of the market. I'm trying to make money. I want you to buy horses from me. Hmm. Police protection. She asked the state or the municipality to protect her investment. That is availing herself of the state. Huh. Now, years ago, part of this was on an actual exam that I did. I threw in the word prestigious horse show, just because I wanted to see if I could spell it. I didn't think it was anything. But a couple of students pointed out that it might be relevant to purposeful availment. Why? Well, because she is attempting to show this horse not at some run of the mill thing, but a prestigious show. So this might be she's really trying to make money here because this is the creme de la creme. Now, is that a big deal? No, it's not a big deal. And if you didn't see it, it's not a big deal, but it might be worth a point here or there. Hmm. Okay. What else do we see in the fact pattern? Well, interesting. The show was at a municipal arena. What does that tell us? It means it's a big place. So we're advertising to a whole bunch of people. This is not a horse show in somebody's backyard. Maybe a factor. Again, if you don't see these, you don't put them in there, so what? Nobody gets all of them. Nobody comes close. What else? Well, let's see. That seems like a lot of availment, doesn't it? She did reach out. Now, is there anything in the fact pattern that shows it's foreseeable that defendant could get sued there? She took out liability insurance. She was nervous about getting sued because of this horse, because horses go berserk and they trample people, right? Horses scare the heck out of me. So she bought insurance. What does that tell you? She foresaw litigation, makes it foreseeable she could get sued there. That supports a finding of contact. Is there anything else? Well, yeah, maybe. This show is at a big arena. What does that tell you? A lot of people, and horses are big animals. And if there's a lot of people, maybe a horse would go berserk, be frightened. So maybe it's foreseeable she could get sued. And again, we just listed a whole bunch of stuff. Most people would get two, maybe. You'd say, well, she sent it there, she advertised. She asked for police protection, something like that. Nobody gets them all. But if you go in with this checklist, you know what you're looking for in the facts. Now, relatedness is a gimme here because this is the only product she sent into the state X, this horse. That's the only thing she's sent into state X, but it caused the injury. So there's relatedness, which means this is specific jurisdiction, which means we have to assess whether jurisdiction's fair. First fairness factor, is there a burden on defendant to litigate in state X? Hmm. Hmm. Well, let's think about that. Defendants usually say, I don't want to travel there, it's not convenient. What fact do we have? Oh, she did not attend the show. Why? Because she, at the time, was at another show in Europe. What does that show? It's at least an argument that traveling to a distant place is not a problem for her. Because after all, she can go to a horse show in Europe. Is it definitive? No, nothing is definitive here. You're just looking for facts. You're just cobbling together the most you can. What is state X's interest? State X is the forum state. What is its interest here? Well, the plaintiff is apparently a citizen of state X, and states like to protect their own citizens, give them access to a courtroom. What else? Well, plaintiff is a police officer. That means she is what? A public servant. And that may mean that state X's interest in protecting her is even greater because she is a public servant. And if she has to go, if she's disabled and cannot sue and get compensation, she may have to go on some sort of support from the state. I also note it's a new municipal arena. The state might be interested here because here's this glittering new arena, and it doesn't want the world thinking, gee, come to our state and get trampled by a horse and you can't sue here, or if you live here. So, look, again, those are all just, this is what I came up with, and I've taught this for 42 years and I've had unlimited time to look at it. So, if you got one of those, you're doing great. But this is how we read aggressively. Plaintiff's interest. Plaintiff's interest. Does plaintiff have an interest in litigating here? Because when you think about it, personal jurisdiction is a question of one thing. What is it? Who has to travel? Does the plaintiff have to go to the defendant's home state, or can we make the defendant litigate here? That's really all it is. So, what is the plaintiff's interest in litigating at home? What is a fact here? She suffered permanent physical injuries requiring lifelong treatment. What does that mean? Very difficult for her to go to Kentucky to sue the defendant. So, efficiency, what is that about? Well, if we have litigation over this, if we go to trial over this, where is most of the relevant evidence? Well, all of the witnesses to the horse show are in state X. All of the medical records are in state X. Plaintiff is in state X, or doctors are in state X. Yeah, there are going to be some relevant things in Kentucky, maybe the records on the horse. Yeah, that's relevant, but certainly it would be efficient to litigate in state X. So we just walk through each one. Shared social policies of the states, I'll leave that one to you. But you see, you go in with this checklist and you made the checklist yourself because you learned the law. And now the fun of it is, let's find some facts. So that's how I would do that. Use the facts, come to a conclusion. Don't be afraid of exams. You're going to know the law. Take this as kind of a fun challenge. Let's go find some facts, scavenger hunt. Nobody's going to get them all. Nobody's going to get them all. But heck, you've done the work. Now have some fun with it. Have some fun with it. And remember, this is all new for everybody. Everybody's in the same boat. You belong here. Believe in yourself. Do the work now. Do the work now. Come exams, you've got this. You've got this. So if anyone is still awake, I'd be happy to take any questions.
Thank you, Dean Freer. That is fantastic. And I know that everyone's favorite subject, if it wasn't before coming here today, is now definitely civil procedure. I think that is evident. We do have a few questions in the chat, so I thought maybe I'd direct the first one to you to take on. So we have a question, which I think is really great. How can we start developing the ability to think about the rules and law in a big picture, connected way from day one, almost like building a framework or skeleton? And what kinds of questions should I be asking myself, whether while reading or in class, so I can grasp the material more cohesively as I'm finding it challenging to connect what I learned early on to what I am learning now?
Every course is a series of doctrines. Every course you'll have in torts, you have intentional torts, and there are a bunch of those, and you have negligence, and there's duty and proximate cause, and all the rest of it. Every course is a series of doctrines. And what I would focus on is learning each one of those. So federal subject matter jurisdiction, we're going to distill that down to a checklist of, I don't know, whatever it is for you, a couple of pages, 3 pages, whatever it is. The cosmic overall view of how justice works is something that you will work on all your career. I'm 72 years old and I've been working on this for over 50 years. So That view is going to come. But in courses, what you end up doing then is when you learn each disparate doctrine, they're not disparate, but when you learn those doctrines, you see they do fit together. Personally, CivPro is a great example. People always say to me, well, CivPro is hard because these things have nothing to do with each other. Au contraire. What happens is you have personal jurisdiction. What does that mean? That's power over the defendant. So you can sue the defendant in a state. Then the next question is subject matter jurisdiction. Well, what is that? That's power over the case. So in that state, you go to state court or federal court. Then you have venue. Which federal court do you go to? When you look at those together, what do you see? They're all about one thing. They're all about forum selection. That's it. They're all about what court do we go to? And so that overarching reality comes out when you study the individual doctrines. Then the rest of Civ Pro largely is a matter of how you litigate once you're in court, pleadings, discovery, et cetera. How do those fit together? But I think learning it Roman numeral by Roman numeral, the overarching thing will come um, when you are able to sit back and look at the whole thing. I hope that's of some help anyway.
Yeah, thank you so much. And we'll get to some more. I think there was an outlining question too, but we'll hold that for now.
Sure.
There's a question on outlining an essay question on whether that is similar to applying the FIRAC to a case. Is that similar or is that different?
Okay, you're going to have to tell me what F Iraq
Uh,
means.
Facts, I think issue rules. I think
Okay.
it's a way of extracting the components of a
Yeah.
case.
I look, I'm old fashioned, I'm old school. It's Iraq. It's Iraq. The facts come in under A. A is analysis. A is applying the facts to the law. Now, here's the deal. In my opinion, and you're going to have to talk to your profs about this because profs can disagree. In my opinion, facts are irrelevant until you have a context. And the context is what is the relevant rule? Until you know what rule, I mean, you can say to me, the process server was 17 years old. Well, that's so what? Why is that relevant? It's relevant because the rule is the process server has to be at least 18 years old. So I believe in making life mechanical and making it easy. And I just do IRAC, and I think the A is the application of facts. But listen, your prof will tell you what she expects. I, for example, tell my students, and I have for all these decades, do not start with a conclusion. Why? Because you may change your mind. The point is to come to the conclusion. Now, having said that, I don't want you to make a mistake because if your prof wants you to start with a conclusion, that's great. And today, now that everybody types out the answers on a computer, that's not that big a deal. But back in the day when you hand wrote them, I'll tell you what I saw all the time. So here, the question is there personal jurisdiction over D? So I'd open a blue book and it's handwritten answer, and it would say there is PJ over D. And then go on a couple of pages, people are writing their answer. Then they go back and they say, oh, no, that's not right. And they go back to the first page. And then they insert, there is not PJ over D. And then they think about it a little longer and then they go back and cross it all out and say, there might be PJ. You don't know your conclusion till you get to it. So I don't know. The New York bar for years told you to start with a conclusion. Then they just got tired of it and they said, no, end with your conclusion. But the most important thing is do what your prof wants you to do.
Yeah,
Absolutely.
I think that's great advice is to ask your professors
Oh,
and give them
no
back
question. No
what they
question.
want.
No question. You can't say, well, the guy on the webinar said, no, no. I, yeah, follow what your prof says.
Absolutely. There's a question here. I can take this one. I've heard about BARBRI's 1L exam success. Can I still sign up to use that? Absolutely. This is an amazing free resource. Many videos from Dean Freer on civil procedure. If you didn't get enough civil procedure today, there is way more for you living in BARBRI's 1L exam success content. There's also a BARBRI legal handbook, and you can get a free trial to Quimby and things on there. So feel free go on there and check it out. We will post a link in the chat so you can figure out how to get on there. But a great resource as you set out to prepare for your final exams. Here's a good question. We've been talking a lot about essays here, but would your approach be any different for multiple choice exams?
Yeah, that's a great question. Again, your professor is your most important resource. And so ask her for, maybe their sample questions and the like. Remember with multiple choice, the answer is there somewhere. The thing about an essay is the answer is not there. Multiple choice, the answer is there. You just have to ferret it out. And I think you need to be comfortable with that. And you need to be comfortable with the fact that certainly on the bar exam, um, the right answer, the answer that gets credit, may not be 100% right. It's just better than anything else. And so, what I do like about multiple choice questions is, yeah, somewhere the answer is there. And as you know from multiple choice questions that you've taken probably throughout your academic life, it's often a matter of paring it down to two more likely choices. Um, Practice is a good thing. Practice is a very good thing. But here's the other thing about multiple choice, and I'll just make this about the bar exam. For years, civil procedure was not on the multiple choice part of the bar examination. Civil procedure only showed up in essays. And my nationwide lecture on civil procedure, when it was an essay subject, was about 4 hours long. Once it became a multiple choice question 10 years ago, the lecture doubled in length. It's now close to 8 hours. Now, why? Because multiple choice questions can get into a little more nuance, a little more detail. And so you can kind of psych this out. And this is not predictive. I'm just trying to say, I'm just thinking about this, that things like dates, like you have 30 days in which to remove a case, things like that are pretty easy to test in multiple choice. And so those sorts of more mechanical things seem to be more likely. A detailed question about personal jurisdiction, like we did with the horse, that's hard to do. That's hard to do in multiple choice. I mean, multiple choice PJ, it's going to have to be something where it's absolutely clear. So you can kind of psych out what is maybe more likely, some of the more mechanical stuff, I think. But again, practice and you know the stuff. I mean, that's the point. You know the stuff because you've listed it. So you could easily imagine that serve as a process question in a multiple choice question, but you've got the checklist. Yeah, it has to be a non-party at least 18 years old.
Great. Thank you. We have another question here, which I think I can predict your answer here. But do you recommend practice exams? And if so, could you talk about when and how to do them?
Yeah. Yes, I do. I do. I don't think you need to do 100 of them, but I do think it's a good idea. And here was my mindset, 1L. I knew nothing about law school. There were no lawyers in the family. Um, but my mindset was, gee, okay, I could do a practice contracts question, let's say, but I'm kind of afraid to. This was odd. I was kind of afraid to because I thought, oh gosh, what if I do crummy on it? But then I realized, well, at some point I am going to sit down and do a contracts essay question and it's going to count. So why would I not practice in the interim? And so do it. The other thing I would sometimes say to myself is, well, gosh, if I'm doing a practice essay question that's taking time away from studying, that's wrong. That's just absolutely wrong. Because when you're doing a practice essay question, you are studying. You are studying. Because this essay question is about, whatever it is, the breach of a contract remedies, whatever it is, and you're focusing on that. I loved the way it worked for me, and it only worked for me because a guy who was living in the graduate dorm with me was in my section. And he just said, Rich, let's go do a practice contracts question. And it was a Saturday morning. I was in law school at UCLA. We went up to the law school. We had a practice question, and he made the rules. He says, okay, we're not talking. Write it out. Outline your answer. Write it out. Get it done. It was brilliant because then I learned from him and he learned from me. It was really so I would do it. Um, I would just start doing it so you're comfortable with it. just be comfortable.
Yeah, I think that's great advice. And we do have tons of practice questions in the BARBRI space where you can see how a rule might look disguised walking around in a different factual situation. And that really only accelerates your learning and understanding.
Absolutely right. I mean, take advantage of what's there from BARBRI. It's fabulous.
Okay, next question. Generally, is it worth remembering case names and citations for exam purposes?
I say absolutely not. Again, rely on your professor. I have never in 4 decades heard of anybody requiring students to know a citation to a case. Uh, but if your prof does that, that's great. That's great. That's fine. But you're going to have to ask that. I myself I don't care about case names. Um, I don't give any particular credit for it. Sometimes they're handy shorthands. But you could get a wonderful grade. You can get an A on that horse hypo without mentioning international shoe. To me, um, if you said, "Gee, the first step under the constitutional analysis is whether there's a relevant contact," and there are two things that go into that: purposeful availment, foreseeability. If you told that to me and then applied the facts, you get no extra credit for mentioning that it's international shoe. But that's me. I don't care about rule numbers, and I don't care about statute numbers, and I don't care about case names. And I think that's true for a lot of profs, but not necessarily everyone. So please, 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 please. These are great questions because you have lots of time to figure out the procedural stuff on the exams with your profs. Great
Yes,
question.
great advice. Um, Here's another one. During essay questions, for example, diversity requirement and subject matter jurisdiction, should one of the factors be clearly insufficient? The value is not over 75,000. Do we lose points for not spending time on the other factors?
Great question. Read the room. Look at the question. Is this a 10-minute short answer question, or is this part of a 60-minute essay? Because it may be that if it's clearly not in excess of $75,000, that means there's no diversity jurisdiction. And so in a sense, it would make no sense to talk about the citizenship stuff. On the other hand, if it's an hour-long essay, then I think what your prof is telling you is please dish to me that you know the citizenship requirements as well. Um, it is an interesting question. It's kind of a tough one, but the California bar, for example, the California bar will have things like that. California bar is pretty famous on the essay portion for being fairly short fact pattern, but a long question. You have a long time to answer. Like you have 50 minutes, 60 minutes. A lot of states you have 30 minutes, but um, it's pretty clear that some states want you to talk about all the requirements. Get a sense of that from your prof as well. But years ago, had a personal jurisdiction question. And as you know, in personal jurisdiction, there has to be a statute that allows it. It's usually a long arm statute. And then if the long arm statute's arguably met, you go on and assess the constitutionality of personal jurisdiction. And years ago, I had a student who's a very successful lawyer here in Atlanta. And we still laugh about this, who went through, and this is a 80-minute essay on personal jurisdiction. And he comes to the conclusion that the statute was not met. And then he says, therefore, I need not discuss the constitutional analysis. And I pointed out to him, I said, how likely is it that we spent 3 weeks on the constitutional analysis and it will not show up on an exam? So you kind of have to read the room in a way. I don't mean to sound flippant, but if there's no AIC, amount in controversy, then you're not going to get a diversity case. Don't forget, though, might be a federal question case in which you get into federal court without, and the amount in controversy is irrelevant. So,
Got it.
but
So I think common sense is still in play, even on exam taking.
yes, I think that's right. I
It'd be
think that's
very
right.
short answer indeed if
And
we had.
indeed, you'll have some where it's just, short answer, 10, 15-minute short answer. And that is clearly not the place where the prof wants you to do the full soup to nuts international shoe analysis. If there's a PJ issue there, it's going to be obvious. Defendant's domicile there, served with process, it's going to be obvious. Yeah.
Okay. Um, let's see. This is a good question. I felt like I was just trying to keep up the first 5 weeks. Is it possible to go back, say in early October, and spend the weekends relearning and reorganizing my notes? In other words, can a student readjust in a big way to catch up if we're still in October?
Sure. Yeah. No, it's great. I mean, we're not in October yet. We will be in a few
Not
hours.
till tomorrow.
But I'll tell you this. That's why I think the timing on this is good. We've got to let folks get into the swing of it. But if you've done nothing in terms of reviewing or outlining, this is a perfect time to start it. And again, you're not, in a way, you're not relearning. Let me just tell you about my law school experience. Let me tell you why I was incredibly lucky. UCLA at the time was on the quarter system. A quarter is 10 weeks. And the way it was set up when I was there was that in the fall, we only had one exam, and it was criminal law. That was it. Courses would continue for 2 quarters, and then you'd have the exam on the cumulative 2 quarters. Property was a year long, and you had a 9 credit exam on one exam for 9 credit hours. So that term, we only had one exam, and it was crim law, and we had 8 days off. I grew up in San Diego. My parents are in San Diego. So I drove home to San Diego from UCLA, and I said, "Oh, I know crim law. I've been studying it all semester." And it turns out I didn't know anything because I really hadn't been distilling as I went. I was able to pull it together in a week, and I learned crim law. And I said to myself, next term, you're going to have 3 final exams. You cannot do this. Therefore, every Roman numeral in every syllabus that weekend, I'm going to outline it. And that's what this is for. And you got time. Absolutely got time. Absolutely.
Yeah, I mean, arguably, I think this is the time where things do kind of start to come together and you're sort of building a puzzle and you're getting a little piece and a little piece. And as you get more of the puzzle pieces, you start to kind of see that big picture. So I'd say it's not too late, and now is the time to jump in and to really dig in and see how these pieces fit
I,
together.
I think that's absolutely right. In fact, really much before this, I think even talking about outlining is premature in some ways because you just don't know enough about it. But now going forward, this is where law school gets tough. It takes discipline. You're constantly looking forward to the next class, reading the material, getting ready, but you're also looking back because you're pulling together all this material. But it's kind of fun. And once you do that distillation, once you put that outline together, man, you got it. You got it. And then you're going back and you're reviewing 2, 3, 4 pages instead of all these notes that make no sense.
Yeah, it's law school, not law prison. I did hear you say that, and I'm going to put it on a t-shirt
Well,
for
that's right. And
after the
I
webinar.
listen, I have wished for 56 or 57 seasons for the Padres to win the World Series. And so I'm wishing again, and I will be watching the playoffs, but I have a feeling I know they are not going to win it. Anyway, that's another story.
Here's a question. What is the best technique to spot the issue at stake? So help spotting issues. Any advice there? I'm assuming within an essay question, but
Yeah, issue spotters. Well, first off, when you do your outline, you know what the big ticket items are. And you also know, as I suggested, for example, in changing of domicile, physical presence is usually not going to be a tough issue. So it's going to be about the intent. So you go into an exam kind of knowing where the flexion points are. And in the checklist, in the outline, one of the things you can do is put an asterisk by something where it's really going to be fact specific, it's going to be fact centric. But issue spotter exams are a staple of law school. And part of that is you've gone to class and you know what the issues are that are important in the class. The big time issues that are important in class are going to be on the exam. Will you miss some on an exam? Of course. I missed, of course, of course. Nobody gets them all, but this is also where practice comes in. I just think go to class. Just go to class and listen and take notes and take notes smart, which means what does the prof think the important issues are in the course? What do hypos look like from this prof? And that informs the way you approach the exam, I think. But absolutely, yeah, and practice exam questions. And you absolutely have time. The way I say it is the way to be relaxed in December is to do the heavy lifting in October and November. And it kind of rhymes, and that's kind of nice. And October starts tomorrow.
Yes, you want to do the installment plan where you're working as you go rather than the balloon payment at
Yeah.
the end because you just have too many exams to really make that all come together in
It is
that
absolutely
right.
right. This is not college, and that's one of the huge differences is you're just dealing with a lot more material. Is it manageable? Yeah, of course. Of course it's manageable, and you will manage it. You are managing it. But I think when you sit down over the weekend or whenever you do it and do the outlining, it just feels good. I would have friends in law school say, "Rich, can I read your outline?" I said, "Sure." I always gave it to anybody because the value in that outline was not reading it. It was, as I said, I didn't put anything down until I understood it. So that was the value.
Related to sort of issue spotting now, but for an essay, can you share some tips on how to strengthen the analysis section of an essay?
Good facts, 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 facts. Because though I say this to my students, and I'm just, it's a little bit of an overstatement, it's a little bit of hyperbole, but you get the point. I tell them that they can know the law better than I do. And I tell them that they can write down what the law is, the rule, perfectly, and they'll get 0 points. Every point they get, and that's a slight overstatement, you'll get something, but every point you get, the major points, the money points, are facts to law, facts to law. So the analysis is here are the facts. And it's not enough just to gather them together. Then you have to see which way they cut. And that's how you argue. Well, on the one hand, this may show that she intended to, this may show that there was consideration for the contract, but on the other hand, this was not discharge of a debt or whatever it was. Yeah, and then you just come to the conclusion. Don't worry about getting the right answer. Um, there's some issues where it's obvious, the 17-year-old process server, yeah, there's a clear answer there. But on the tough stuff, which is usually what you're doing on essays, the answer is far less important than that analysis. But it's all driven, I think, by facts. You know the law, you will know the law. Um, Now find the facts.
Yeah, and I think we have a host of resources for you to dig in and practice this. Analysis is such a skill that you are building in this first year. So we do have some helpful practice essays and sample responses where you can kind of see how the facts are being used in an analysis in an effective way. So
Exactly right. Exactly right.
let's see. What do you think of a second, shorter attack outline? Citing to and being paired with a main outline. Do you agree with that strategy?
I actually did that. I actually and I did it years before I ever heard the phrase attack outline. That's how I did it. I didn't set out to do it that way, but I was putting my outline together and then when I was reviewing a section on it, let's say on torts, I don't know, negligence or something, um, then I said, well, yeah, that's good, but I can actually make it shorter. It's sort of like the almost the table of contents version, and um, that works. Um, a lot of people don't do it. I think it's hard. Yeah, I think it's hard to tell people how to outline. It's something you just need to learn. And I'll tell you, here at Emory, we have a first year course, Elements of Legal Study, that starts at orientation about the skills of law school. And obviously, we're going to learn the skills of practice of law, but the skills of law school. And that course follows you throughout your entire first year. And so at orientation, it's about cases and what are cases and how do you read a case and what is critical reading and so forth. But but That class then, as it unfolds, has just now gotten to the point where they're discussing outlining. So this is actually a perfect time to do it. So uh, the attack outline may be something that comes to you later. That's fine. One thing to remember too is the outline is a tool. It's not an end in itself. And one of the things on an exam to remember is you want to focus on answering the question that is asked and not just kind of showing off your outline. One of the frustrating things about exams is you're going to know a lot of stuff that's not asked about, and it's a little bit frustrating. But you're ready. You're ready because you've done the heavy lifting. Yeah.
Yeah, that's great advice. I always tell my students it's the process of building the outline that is actually where the value really lies. There's some value in the product, but it is that process of going through and connecting concepts, figuring out, wow, I didn't know that as well as I thought I did. Maybe I could state the rule elements, but I don't know what they mean. And so I
Yeah.
think that process of building your own outline, you're going to find is such a valuable experience to go through. And
It
that will
is.
be totally personal to each person, to the way that you learn best and the things, maybe you need more examples or maybe you need a flow chart. So do keep that in mind. It's a personalized journey that we all take. And you're gonna figure out a lot about what works for you and what's not gonna work for you in this first semester.
I think that's great advice, and also the 1L success videos are helpful. What I do there in the Pro stuff is I'm trying to create an analytical approach. So the personal jurisdiction section is pretty long because we go through the history. But the bottom line is at the end of that, I say, here is how you do PJ. And I think it's very linear. And yet I've had students say, well, that's great. I appreciate that. But for me, I need to put it more in a flow chart. And that's great. That's great. That's great. However you do it, it's up to you. Yeah, it's good.
Yeah. This has been so helpful, Dean Freer. You are really been just amazing. It's been so great hearing you. I know that I speak for everyone in attendance that we really appreciate you spending the time with us and acclimating us to first year and what it's going to be like and making us all love Civ Pro even more. So thank you to everyone who joined and for submitting questions. And we hope to continue to hear from you along the way in your law school journey. And thank you again to our Dean Freer for joining us. Big round of applause. I'll clap from the audience. I know they're all
Thank
saying
you.
thank you in the chat right now.
Thank you.
Uh,
It's my pleasure, my honor. And let me just tell you, remember, you belong here. You're here for a reason. You've succeeded at everything you've done. And there's no reason to expect that that's not still true. Of course, it's true. Of course, it's true. Just get in there, give it your best shot.
yes, amazing and important advice. Thank you, and everyone have a great week. Thank you so much.
Thank you. Bye bye.